In this video, we will discuss about the Representation of the People Act of 1951. So firstly, let's have a look at its key provisions. So the first one is that it regulates the actual conduct of elections and by-elections. The second one is it provides administrative machinery for conducting elections. Then comes it deals with the registration of political parties. It specifies the qualifications and disqualifications for membership of the houses. Then it provides provisions to curb corrupt practices and other offences. And lastly, it lays down the procedure for settling doubts and disputes arising out of elections. So these are the key provisions of this act. Now let's have a look at the qualification for contesting elections in India. So the Parliament has laid down the following set of qualifications in order to contest the elections as per the Representation of People Act of 1951. So a person must be an elector in the constituency. The person must be a member of a scheduled caste or scheduled tribe in any state or any union territory if he or she wants to contest a seat reserved for them. Then after that, the minimum age for becoming an MP or MLA of Lok Sabha is 25 years. And then at the panchayat and municipality levels, the minimum age limit for contesting elections is 21 years. Now when we talk about the right to vote, then apart from Article 326 of the Constitution, which guarantees the right to vote to every citizen who is above the age of 18 years unless disqualified by any law, Section 62 of this Act also ensures that every person who is in the electoral roll of that constituency is entitled to vote. One person can vote at one constituency only and only for one time in a particular election. Then if a person is confined in a prison, whether under a sentence of imprisonment or transportation, then he is not eligible for voting. However, in case of preventive custody, he can vote. Then in 2014, the Election Commission of India had said that the person under preventive custody had the right to vote, but not under trials and convicts. So, a person who is under preventive custody can vote, but those who are under trials and convicts, they cannot vote. However, the Act allows those serving sentences less than 2 years to contest elections from the prison. Now, there is one option which was introduced in 2013 and it is known as NOTA. So, it stands for none of the above and it was introduced in the ballot papers or EVMs in general election to the state assemblies in 2013. After this comes the VVPAT, so it stands for Voter Verifiable Paper Audit Trail, and it is an independent system attached with the EVM, which is the electronic voting machine that allows voters to verify that their votes are cast as intended. It was introduced in 2013 after the Supreme Court allowed the Election Commission of India for the requirement of free and fair elections in its verdict in one of the important cases, which is People's Union for Civil Liberties versus Union of India case of 2013. Then after this, we'll discuss the provisions related to political parties. Every association or body, in order to become a political party, must be registered with the Election Commission of India, whose decision regarding registration will be final. Now, registered political parties in course of time can get recognition as state party or national party. Change in name and address of a registered political party must be communicated to the Election Commission of India, and the Election Commission of India cannot de-recognize a party. After this, we will discuss the right to information. So candidates need to furnish information whether he or she is accused of any offense punishable with imprisonment of 2 years or more in a pending case or has been convicted of an offense. Then comes the option of declaration of assets and liabilities. So individuals contesting elections have to file an affidavit declaring their criminal records, assets and liabilities and educational qualifications. And after getting elected, MPs are required to file a declaration of assets and liabilities with the Speaker of Lok Sabha and the Chairman of the Raj Sabha. These declarations have to be made by MPs within 90 days of taking their seats in Parliament. After this comes the voluntary contributions. So voluntary contributions by any person or company within India other than a government company can be accepted by the registered political party. A company can donate any amount of money to any political party. There is no obligation of the company to report such donations in its profit or loss account. it is mandatory for political parties to submit to the Election Commission of India a list of donations they received above rupees 2000. Political parties cannot receive more than 2000 as cash donations. Now, political parties are eligible to accept contributions from foreign companies also, and it is defined under the Foreign Contribution Regulation Act of 2010, which is called as FCRA Act. After this, we will discuss voting through postal ballot. Any class of person can be notified by the Election Commission of India in consultation with the concerned government, which can give their votes by postal ballot. Section 126 of the RPA is also important. So this says that 48 hours before the polling ends or concludes, displaying of any election matter by television or similar apparatus in a constituency is prohibited. And section 126 is not applicable to the print media, news portals and social media. Also, section 126 prohibits the conduct of exit poll and dissemination of its results during the period mentioned. Then comes the counting of votes. At every election where a poll is taken, the votes are counted by or under the supervision of the returning officer and contesting candidate and his election agent and his counting agents. Now, destruction, loss, damage or tampering of ballot papers at the time of counting must be reported by the returning officer to the Election Commission of India. Let's discuss now about the corrupt practices. So all the government or non-government officials are included within the scope of the corrupt practices. Bribery, any gift, offer, promise or gratification to any person as a motive or reward. Undue influence, any direct or indirect interference or attempt to interfere on the part of the candidate with the free exercise of any electoral right. Then comes the publication by a candidate any statement of fact which is false in relation to the personal character or conduct of any candidate. Then last is the hiring or procuring of any vehicle by a candidate of any elector to or from any polling station. After this comes promoting enmity. So under this, any person who promotes or attempts to promote on grounds of religion, race, caste, community or language feelings of enmity or hatred between different classes of citizens of India can be punished with imprisonment for a term which may extend to 3 years. Now, provision of public meetings during a period of 48 hours ending with the hour fixed for the conclusion of the poll. So these are the two provisions for promoting enmity. Then after that, disqualification of MPs and MLAs. So RPA 1951 lays down certain rules for the disqualification of MPs and MLAs. Section 8 clause 3 of the act states that if an MP or MLA is convicted for any crime or is sent to jail for 2 years or more, he will be disqualified for 6 years from the time of release. And even if a person is on bail after the conviction and his appeal is pending for disposal, he is disqualified from contesting an election. Further, Section 8 Clause 4 allowed for convicted MPs, MLAs and MLCs to continue in their posts provided they appealed against their conviction or sentence in higher courts within 3 months of the date of judgment by the trial court. And Supreme Court in July 2013 struck down Section 8 Clause 4 of the RPA 1951 and declared it ultra vires and held that disqualification takes place from the date of conviction. So what we learnt is that Section 8 Clause 3 of the Act is still valid and it is considered in terms of disqualifying any MP or MLA. And how it was done? It was done on the basis of any crime which was done by MP or MLA for which he is sent to jail for 2 or more years, he or she will be disqualified for 6 years from the time of release. So this was the overall feature of the Representation of the People Act of 1951 and it is very much significant. Now let's have a look at the significance of the acts. So it promotes direct democracy, it accounts for equal representation, then it promotes federalism, it also helps in decriminalizing Indian politics, it enhances accountability and transparency, and it helps for conducting clean election, and also it is helpful in legible political funding. So overall what we understand is that the powers of the Election Commission of India are enormous and all encompassing, which even exceed the powers of the executive in all election related issues during the course of the election period, thereby giving it effective tools in dispensing free and fair elections. The only thing that lacks is the will and integrity on the part of responsible officials. So Election Commission of India should become more prudent and proactive in order to ensure the fairness and transparency of the general election, and they must also wipe away any doubt regarding its integrity as an esteemed institution. So this is it about this video, and I hope you like this video. So thank you so much for watching.